to share it with you. This is the small quote by famous author Arthur Miller. So he was saying that in 1964, the apple cannot be stuck back on the tree of knowledge. Once we begin to see, we are doomed and challenged to seek the strength to see more, not less. I would like to welcome Dr. Saunders to start the session. Thank you.
Good afternoon. Well, first I'd like to thank our organizers. This is a fabulous thing you do, and the Graduate Student Association. Your work is really important, and these kind of events just make the whole university a much better place. So thank you for your efforts. So it's my pleasure to moderate today's session. As we heard, we're going to have 3 speakers, 15 minutes each. They're coming from quite different disciplines. So our goal here is to learn something new about disciplines we may not know anything about. I'm going to try to synthesize it at the end there, and I'll try to help do that at the end. So our first speaker is Amanda NeMoyer. Amanda is a PhD candidate in the psychology law program, so she'll graduate with both a JD and a PhD. I'm going to read her bio. Amanda is a rising 4th-year student in the law psychology PhD program with Drexel University's Earle Mack School of Law. Her research interests are in juvenile forensic psychology. Specifically, she's interested in evaluating current juvenile justice practices, investigating the potential need for reform, and advocating for policy change. She works with Dr. Naomi Goldstein in the psychology department, and recently completed her master's thesis, which I think we'll hear a little bit about today. And that thesis is entitled Identifying Predictors of Juvenile Probation Violation and Success. In 2013, Amanda won a Student Travel Award to present at the annual American Psychology and Law Society Conference, and she also won first place in the oral presentation category at the College of Arts and Sciences Research Day. So without further ado, welcome Amanda.
Hi, so as you heard, I'm Amanda NeMoyer, and my fields are law and psychology, and this Books and Bagels was kind of marketed as topics of interdisciplinary research. And so it's kind of obvious how, or it seems like it would be obvious how law and psychology would be pretty interdisciplinary. You've got law, you've got psychology. They could be very different, very diverse fields. But a lot of times when I say this is what I do, I still get a lot of questions. Mostly I get a question about, like how do those fields really even intersect? Or for my law school friends, they say like, what are you going to be, like a criminal profiler or something? And that's not really what I'm going to do, but it is a possibility, I suppose, but there are a lot of different areas where psychology and law kind of intersect and can work together to really inform people. And these are just some examples, but there's a ton more. There's like risk assessment, there's competency evaluations, there's offender treatment for offenders who have mental illness. There's just a lot of different areas where psychology and law intersect. But what I'm most interested in is kind of specific to the juvenile justice system and looking at youth capacities and how they kind of behave as part of the juvenile justice system and how it could be improved. So specifically in that field, there's been a lot of research in the past that kind of demonstrate that youth are fundamentally different from adults, especially in terms of their capacity for mature judgment. Brain research has shown that youth just have very different brain structures than adults because they're still developing. Specifically, the amygdala, which is involved in emotional response, is still developing. The prefrontal cortex, which is involved in planning and inhibition and other executive functions, that's still developing. And a lot of times that doesn't fully develop until we're in our mid-20s. But in the meantime, youth who have these kinds of deficits are more likely to engage in risky behaviors like criminal activity. And they don't really, and research into decision making with youth kind of has shown that kids don't really take into consideration the long-term consequences. They're more concerned with the immediate rewards. And these kinds of decisions are really important in a legal context and just in everyday life when they're deciding whether or not they want to engage in these criminal behaviors. Another thing that research has shown us is that youth are more vulnerable to external influences, so their family, their friends. A lot of times when kids commit crimes, they're doing it as part of a larger group. Their need for peer approval, their fear of rejection, it comes into play a lot when they're deciding whether or not they want to participate in these criminal activities. And the last thing that we, as researchers, have found is that youth have a greater capacity for change and reform. Just because a youth is involved in a crime, a minor crime, when he's 12, 13, 14, 15, doesn't mean he's going to continue this kinds of behavior when he gets older. Identity formation is still going on until you're in your 20s. The capacity for reform is greater. And the Supreme Court has recognized this research, which is pretty cool, because the Supreme Court works very slowly, but in recent years they've kind of taken into consideration these decades of research that has shown that kids are a lot different from adults and they don't deserve to be treated the same. So for example, in 2005, the Supreme Court abolished the death penalty for all juvenile offenders. And in 2010, they abolished life without the possibility of parole for juvenile offenders who commit non-homicide crimes. And then in 2012, so just last year, they abolished mandatory life without parole, all cases of that, so even homicide crimes. They abolished the mandatory imposition of that sentence. So in each of these opinions, the Supreme Court has cited social science research, specifically psychology research, that has shown these three kind of facts: that youth and adults don't deserve to be treated the same. And so even though this kind of has been shown on a larger scale in terms of the Supreme Court, there's still a lot of smaller scale questions that we can investigate as youth and law and psychology, people with those interests. So specifically, because this is such an interdisciplinary field, we get to collaborate with legal experts, which is really cool because they might not have a background in psychology, but they have a lot of other knowledge that's really relevant to what we're studying. So we can ask, what do you think would be helpful to a lawyer who is representing youth? We can ask, how can we best use the information that we find to make change, to get this out to the public, to get this out to lawmakers, whoever it would be relevant to get this information out to. And just specifically, we get new sources of data. So for example, my thesis, which I'm about to talk about, I got the data from the Defender Association of Philadelphia, which is the public defender's office in the city. And the reason it even came about was because myself, my advisor, and a lawyer at the Defender Association were talking about the fact that a lot of kids get put on probation. This is a big flow chart, you don't have to read all of it, but this is kind of the progress of kids through the juvenile justice system. And the majority of kids who are adjudicated delinquent, which is kind of the equivalent of being found guilty in the juvenile justice system, are put on probation, about 60%. And then there's also a bunch of youth who get put on probation who haven't been adjudicated delinquent, but just get kind of diverted that way. So for those of you who don't know, probation, they get, rather than going to prison or going to a youth facility, they have to comply with a number of requirements that the judge imposes. In Pennsylvania, they're imposed for an indeterminate amount of time till the judge says, okay, now you're free, you don't have to keep doing this. But there's a lot of information that we don't know about probation. So the three of us were kind of talking about this, and we kind of identified some important facets of the area of juvenile probation and things to look for. So we wanted to know what requirements are being imposed on kids. What are they being asked, being forced, being told to comply with? What are the probation requirements that they're not listening to? What are they being brought back into court and saying, if you don't follow these, you're going to go to a youth facility, a correctional facility. And then in the long term, we're hoping to see if there's any predictors of noncompliance with probation requirements. So just to see if we can identify these youth early, what can we do to kind of help them along so that they're less likely to kind of violate the terms of their probation. And so this was my master's thesis. And we looked at just basically what we kind of identified as things that needed to be investigated. And the last one is we just looked to see if there were any predictors in terms of what probation requirements were imposed to see whether those youth would eventually not comply with those requirements. So this is just some basic information about the records that we found from the Defender Association. We looked at 120 kids who were put on probation for arrests that happened between January 2005 and December 2007. They were between 10 and 18 years old, but the juvenile justice system has jurisdiction over kids until they're 21. So some of them were older by the time they finished, but they started between 10 and 18 years. And they were mostly males, and they're mostly African American because this represents the type of population that the Defender Association works with. So these are all the different types of requirements. As you can see, there are quite a bit. You can't read it because it wouldn't fit otherwise. So we're just going to talk about the top 5. So mandatory school drug screens, curfew, this youth advocacy program, and community service. Those are the top 5 most imposed requirements. There was between 0 and 13 requirements imposed on youth just of the sample, and the average was about 5 as the greatest number given at any one time. So that's why I kind of focused on these top 5. But these were all imposed on at least 35% of the sample. But we also found some interesting percentages when we were looking at the descriptive statistics. We found that more than 67, so about 2/3 of youth were required to undergo drug testing as part of their probation condition. And that seems to make sense. But fewer than 1/3 of those youth were also required to attend drug and alcohol counseling. So they're being told to not do drugs, but they're not really given the support that's needed for them to overcome a drug addiction if that's what they have. Also, sort of along the same lines, fewer than 1/4 of them were ordered to attend drug and alcohol counseling or receive mental health counseling. So there was no real indicator of whether the youth had mental illness or not, but we just kind of wanted to know how many of them were receiving these kinds of counseling. And only 2 youth were required as part of their probation to attend both drug and alcohol and mental health counseling. So it seems like there could be more support systems put in place. But then we wanted to look to see what requirements weren't being complied with. And so we found that drug screens, this alternative educational program that they often mandate, and mandatory school, so going to school and doing well in school. Those were the most commonly violated, in about 20% of the sample at least. And then about 30%, maybe a little more, violated also via rearrest. So they got arrested again, which would be in violation of their probation requirements. This I'm just going to kind of breeze through, but this is, we just looked to see if any of the specific conditions predicted whether a youth would kind of not comply with the terms of their probation. We saw that drug and alcohol counseling and mandatory drug tests both did that, but that doesn't mean that those were the ones that they violated. So I guess what I was talking about before was about how this research can be applied directly to kind of reform. So when we find that more than half of the youth fail to comply with their requirements at least once, it suggests that something's not working that well. It's not a very good grade, I guess you could say. So when we see this, we kind of wonder, what can we do about it? So kind of as I mentioned before, the types of conditions imposed. By looking at the common conditions that are imposed on youth, we can see which ones are being violated, which ones might be problematic, and which ones could maybe use some additional support. So if you're telling a kid not to use drugs, which is a valid thing to tell them, maybe provide them support in order to do that, rather than just kind of leaving them to their own devices. The other thing we can learn by looking at commonly imposed conditions is how judges think, and it seems like a lot of time they want to curtail problem behaviors. So they say, don't do drugs, don't stay out late if they impose a curfew, go to school. But sometimes they also seem to kind of encourage good behaviors. So do community service, participate in this kind of Big Brothers Big Sisters program, go to this GED program if you're not going to school. But this seems to be a little bit less common, so it kind of gives us a little bit of insight on what judges are thinking, and potentially that can help us and help lawyers in the future when they're talking to judges about what kind of conditions they want for their clients. So this is also just kind of harping on the same thing. Most of the youth who violated did so via drug testing, and substance-related requirements imposed on the kids predicted the fact that they wouldn't comply with their requirements. So just talking once again, Support services is something that could be really a good improvement, we feel, because only 15% didn't go to drug and alcohol counseling when it was imposed, so it seems like this is something that kids are willing to do. And so just collecting more of this data we feel would be very helpful to juvenile justice personnel because it shows which conditions are maybe not working so well, which ones could use some supports, and defense attorneys can use some more unique conditions with judges if that's what they think their clients need, if they can show that they've worked in the past. So that's kind of my talk. I just kind of wanted to talk a little bit about the field generally, about the specifics of youth, the juvenile justice system and how psychology research can kind of apply and help reform it. And I also wanted to talk a little bit about my thesis and share the results in case any of you are interested in that. So that's pretty much it. Thank you very much.